This is Syndication Attorney Field Notes. I'm Tilden Muschetti, and I'm a syndication attorney. Today's field note is about the investor questionnaire in a Regulation D private placement and what it's actually supposed to prove before a sponsor accepts money. Here's the scenario I keep seeing. A sponsor calls me and says, I found an investor questionnaire online, I put my logo on it, and I dropped it into my subscription package. And I ask one question. Does the form ask about accredited investor status, or does it ask how the investor feels when the market drops? 9 times out of 10, it asks about feelings, and that means it's the wrong form. So let me give you the direct answer. In a Regulation D private placement, the investor questionnaire is not a retail risk tolerance survey. It's a legal gatekeeper. Its job is to document whether the investor is legally eligible to buy the securities. That usually means whether they're an accredited investor. It's about legal eligibility, not financial advice. Think about it that way. You're not advising the investor. You're documenting whether they're allowed through the door. That's the whole purpose of the form in a syndication capital raise or an investment fund offering. Now, why do so many sponsors get this wrong? Because the word questionnaire sounds generic. So when you search for it, you land on brokerage and financial planning forms. Those forms ask about time horizon. They ask about goals. They ask how you feel about volatility. And that framing exists for a reason. It's just a different reason. Retail brokers assess suitability, which asks whether an investment is right for a particular person. That is not the question a sponsor in a private placement has to answer. So the sponsor ends up with a polished, official-looking form that asks all the wrong questions. It measures feelings about risk. It doesn't capture income. It doesn't capture net worth. It doesn't test entity status. It collects none of the data that actually matters for the exemption. Some of those templates aren't even built for U.S. offerings. They come from other countries' rules. They look legitimate, and they are for their own audience. They just leave a U.S. sponsor with nothing. So here's the distinction that matters. Suitability asks whether the investment fits the person. Regulation D eligibility asks whether the person is even allowed to participate. The right questionnaire tests income, net worth, entity status, and sometimes sophistication. Let me make that concrete. Picture an investor who owns a $2 million home, free and clear. On paper, they feel wealthy, but they only have about $100,000 in liquid assets and investments outside the home. Now, a generic form might let that investor count their home equity toward net worth. And if it does, it'll tell you they're accredited. But here's the rule. In a Regulation D private placement, primary residence equity does not count toward the $1 million net worth test. It has to be excluded. So a properly framed questionnaire forces that exclusion, and it surfaces the truth. This investor may not meet the net worth test at all. The generic form hid that. The right form found it. Now, here's a piece a lot of sponsors miss. One questionnaire does not fit every deal. The legal weight of the form changes depending on which exemption you're using. Under Rule 506B, the no advertising path. A properly drafted questionnaire lets you form a reasonable belief that the investor is accredited, based largely on their self-certification. If they check the right boxes, sign, and nothing contradicts it, that signed form is a foundational piece of your file. And 506B also allows a limited number of non-accredited investors, but only if they're sophisticated. So for those investors, the form has to document their actual knowledge and experience, not just a checkbox. Under Rule 506C, the path that lets you advertise, the bar goes up. A signed questionnaire is not enough by itself. You have to take reasonable steps to verify that the investor is accredited. Self-certification is not verification. So in a 506C deal, the questionnaire is really the front end. It routes each investor toward how they'll prove it, tax returns, brokerage statements, or a letter from a CPA or attorney. The form sets up the proof. It doesn't stand in for it. So reusing a 506B questionnaire in an advertised 506C leaves out the whole verification machinery. Same word, different job, a few things not to assume. Don't assume a signed questionnaire is a magic spell. It's a shield, not a magic spell. If an investor certifies a $2 million net worth and then asks if they can fund the deal on a credit card because their account is empty, those facts don't sit together. When the facts and the form conflict, the reasonable move is to ask more questions, not fewer. Don't assume professionals are automatically accredited. A CPA, a lawyer, a real estate broker, none of those titles by themselves create accredited investor status. Only certain securities licenses count. Everyone else still has to meet the income or net worth thresholds. And don't assume an entity qualifies just because it exists. A brand new LLC with no assets doesn't qualify on its own. Either the entity holds enough of its own assets, or you look through to the owners, and each of them has to be accredited. So here's the field note. The investor questionnaire in a Regulation D private placement is not paperwork filler. It's the gatekeeper for your exemption. The retail version measures how someone feels about risk. The Regulation D version measures whether they're legally eligible to be in your deal. Match the form to the exemption you're actually using, and don't ignore the facts sitting right in front of you. The longer written version of this is in the show notes. I'm Tilden Moschetti, and this has been Syndication Attorney Field Notes.